Welcome once again, everybody, to our third panel of our Spring Symposium on Climate Change in South Asia. I'm Anna Sturr, and I'm the Director of the Center for South Asian Studies. And this panel is entitled Climate Justice and the State. Our first presenter on this panel is Samson Kayam from the University of Melbourne. And Samson is going to be speaking about revitalizing hydraulic civilization, crisis and state power in post-conflict Sri Lanka. Welcome, Samson. The floor is yours.
Right, thank you so much for that introduction. I'll just share my screen. Okay. Okay, so I'll get started. So an acute drought swept through the dry zone of Sri Lanka across 2016 and 2017, and irrigable water was withheld from wet rice farmers in Polonnaruwa district. So intensive negotiations were undertaken between farmer organisations and irrigation departments to ascertain an appropriate time and amount of water for release to ensure an adequate harvest without excessively depleting water reserves. Of course, these negotiations were tense, where antagonisms between farmers and government gradually increased. As the drought continued, a sense of crisis grew. Amplifying the crisis of drought was the nature of Sri Lanka's post-conflict reconstruction at the time. The then President, Maithripala Sirisena, hailed from Polonnaruwa district, where my research was undertaken. As many of his predecessors had in their home districts, he set about developing Polonnaruwa and elevating its national status. Much of these activities emphasised and enlivened Polonnaruwa's previous status as a hydraulic civilization that had exhibited considerable hegemony over the island and the broader region during the medieval period. Generally imagined as a Sinhala Buddhist civilization, despite evidence to the contrary, and Sinhala Buddhists are the ethnic religious majority and who I focus my studies on. Despite evidence to the contrary, President Sirisena re-mythologized the kingdom of Polonnaruwa in speeches and opening ceremonies, highlighting how various kings had overcome South Indian aggression to establish and maintain the capital. So Sirisena was revitalizing hydraulic civilization to signal a renewal of Sinhala Buddhist hegemony following the government defeat of the Tamil Tigers in 2009. That's the nature of the civil conflict. Therefore, the drought, a deprivation of water, the very substance that sustains hydraulic civilization, threatened to derail his project. So that's the kind of context. So here's a map. Polonnaruwa is just sort of down there to the right. So my approach to studying the effects of drought in Polonnaruwa was to engage with farmers and government across a system of interconnected hydro infrastructure. So here's a map. There are four major water tanks in the district, and they're fed by diverting terrestrial water and the capture of rain that falls in limited monsoonal seasons. So I chose three tanks. So you've got the top one here, 2, 3, Mineria, Caldula and Giatale. This is probably not particularly clear, this map, but this is all the irrigation systems there. And then there's the fourth one. So I focused on the top three and they're all interconnected. So I spoke to farmers at close, intermediate and distant zones from these tanks to engage with them. Farmers are primarily grouped into organisations called Govi Sanvidanas or GSVs. These are legislated bodies that farmers pay an annual membership to participate in, and they're delineated by the irrigation systems. So you'll have one group is Irrigation Canal A, Irrigation Canal C, and everyone's a member, able to be a member between those canals. They emerged in the late 80s through the government's commutation of a water tax levied at irrigable water users for their upkeep of tertiary and secondary irrigation systems, which had previously been the purview of the government. So rather than cash, you give us your labour. GSVs are managed by an elected board. Elected members have delineated terms and limitations on re-election, and thus GSVs refract democratic principles. GSVs are the primary way that government interacts with farmers and distributes resources to them, with the state having a consistent history since independence in 1948 of intervening in rice production through programs such as fertiliser and paddy seed subsidies, as well as various iterations of rural financing and loan schemes. GSVs are also the way that farmers advocate for their interests, and as some GSV leaders told me, often how they've organised to vote in elections, so they're quite politically potent as well. The local officers of the Irrigation Management Department and the Irrigation Department were drawn into regular meetings with GSVs across my field site during the drought. And I would take the content of these meetings as discussion points to then go out and talk to farming households. And through that, it became clear that the patron client networks that shape the area that I worked in were increasingly becoming under strain in the drought. GSV farmer constituents expected more from their patrons, and many patrons felt under intense pressure. So I use that patron loosely. I'm talking about government agents as well as the GSV leaders themselves. So within this tense milieu, farmers expressed on several occasions that they were going to organise into open protest against the government. Farmers' frustrations and plans to protest were generated by the fact that the government continued to promise water but deferred its release several times over, and farmers had had enough. However, these protests never eventuated in any real way. Why was this the case? So this question sort of at the heart of my paper. So why did this never sort of occur? Sri Lanka is a democracy, and Sri Lankans aren't shy of a protest. I've got some photos here of protest by farmers protesting the ban of chemical fertilizer in 2021. So they certainly aren't shy of doing it. This was also evinced recently when about 10,000 or more people stormed the presidential palace in 2021 to oust the president, and there was farmers involved in that as well. So the lack of farmer protest, despite their expressing their interest to do so, cannot just simply be hyperbole. Okay, they're talking a big game and then just never carried through. I don't think that was the case. Considering the heavy presence of the state in rice production and the attached patron-client networks, it might be argued that farmers were in too weak a position to openly protest. When the government controlled flows of water and the provision of key resources and financial aid, and GSV boards generally taken from the rural middle class, often having wealthy patrons of their own to secure resources for their constituents, it could be argued that perhaps it's too great a risk for farmers to engage in open protest. A corollary to this kind of position, some scholars of Sri Lanka, Mick Moore and De Zoysa, have pointed to the atomisation of farmers in the latter half of the 20th century. Moore has pointed out that the state retains land tenure systems which only allow smallholder farming. So there's a lot of government leased lands. Most farming families don't have more than, say, 2 acres of paddy land. De Zoysa has pointed to economic liberalisation, which was undertaken in 1977, which opened rural areas up to a kind of capitalist dynamic and an individualistic ethos. So these two thinkers sort of say, well, there are certain obstacles to farmers collectivising, and they posit, well, this is why we don't see perhaps some of these bigger protests that I'm talking about. However, that being the case, I've sort of reflected upon some of James Scott's work and Weapons of the Weak, and he's considered some of the subtleties of peasant resistance and their occurrence at the level of the everyday. Importantly, he's highlighted how peasant resistance is often uncoordinated and constituted through the particular cultural idioms of any one society. So with this in mind, it gradually became clearer that farmers in Polynarua were protesting their circumstances, but in ways that were far less explicit than taking to the streets. So an issue that revealed itself as the bane of GSV leaders and irrigation departments alike was the abandonment of obligations for irrigation canal maintenance. Canals became overgrown with their weeds and their banks deteriorating. Many outstanding repairs were left unattended. So this is a duty of the GSV. Such abandonments were quite curious to me because they weren't uniformly undertaken. In some villages, it was endemic, and in the adjacent village, it was not. Likewise, one irrigation canal, people seemed to be undertaking this practice, and another right next to them, they weren't. And when I went to investigate the phenomena, farmers routinely denied participating in it, in fact, almost always. So it was always, oh, it's my neighbour who does that. Oh, it's my family member who does that. One of those tenant farmers overdone it. I don't do that. It's not me. It's never me. And those in elected positions in the GSV often condemn the practice. So when water was released eventually, particularly in Caldula and Gitwe, it was the most protracted, it actually needed to be shut off again because they needed to attend to the repairs and the overgrown canals. So in this sense, the abandonment of labour obligations seemed to me to be quite counterintuitive, really. So why would you do this? Abandoning irrigation maintenance did elicit the attention of the government and became a much maligned topic in meetings between farmers and the irrigation departments. Department managers expressed their frustration at GSVs about this spreading phenomena, demanding its cessation. Routinely, they would threaten to withhold resources like water and fertilizers to those who did not perform their maintenance duties. And among GSVs, several leaders resigned from their positions prematurely, sparking elections. At these elections, the leaders named the abandonment of maintenance as a central issue, citing as a clear indication that their constituents no longer respected them. So without doubt, this practice presented a crisis for leadership at various levels of governance. So at one level, abandoning maintenance expressed an unwillingness to cooperate. Obligations for maintenance are enshrined in an irrigation ordinance, and this is an affront to the government. Furthermore, the heavy intervention of the state in rice production at one level is to ensure domestic supplies of rice in what is an export-oriented economy. Thus, this practice of abandoning maintenance halts rice production, which the government is tasked with maintaining. And furthermore, what it also appeared to do was attack patron-client networks, GSV leaders resigning, the government upset about it. So in essence, abandoning maintenance was a form of protest, albeit less explicit than picketing. It was explosive because it amplified the emergent sense of crisis and created a real sense of upheaval in the social order. It came at a price, though, as it had detrimental effects on farmers themselves. But, in essence, they were exercising their autonomy whilst being highly cognizant of their dependent position, it seemed to me. And it lacked really any discernible leadership. It seemed to me a coordinated, thought about thing. And so this form of protest was slightly covert, and it reduced the risk of producing any pronounced targets for reprieve. So when I opened this presentation, I said that the then president was revitalizing hydraulic civilization at Polonnaruwa. With this context in mind, what is significant here is the historical relationship between irrigated wet rice farmers and kingship in Sri Lanka. Oviasekara, across some of his works, has noted how when the Buddhist king overreached his power, or when disorder was evident in nature, his leadership was called into question. This was done by farmers abandoning their corvée labour duties, which, as Roberts notes, included irrigation works. I'm talking about the kind of ancient time now. In fact, Obiasekara notes the presence of the Patia play, which is a play which was evidence of this practice, a play that explicitly lampoons the despotic king who overdemands corvée labour or breaches his duties, and farmers respond to him by downing their tools. In the Kandyan kingdom in the 19th century, Duncan notes how King Sri Vikrama Rajasinghe, the last king of Sri Lanka, directed corvée labour toward the building of an ornamental lake. Soon, farmer labourers downed their tools, seeing the construction and overreach of his power as the lake wasn't going to support irrigated cultivation. There is, therefore, a tradition of farmers abandoning their obligations of constructing and maintaining irrigation systems as a protest in relation to the polity condensed in the figure of the king. Abandoning work obligations by farmers is a culturally sanctioned form of protest ensconced in the ongoing ideology of kingship amongst Sinhala Buddhists. So on this point, kingship as an ideology persists in Sri Lanka. President Sirisena certainly wasn't doing anything new as a head of state when he compared himself to the ancient kings consistently in his opening projects. Silens and Graeber point out to the habitus, I better hurry up, sorry, as an ongoing thing. So this is a persisting phenomena. Some Sri Lankans have commented on that, particularly in the position of nationalism, except they tend to say that people strategize and use this ideology to amplify their personal power. And I see in this a kind of position of a dualism of action and ideas, and that people are rational beings, where in this instance I don't deny that, but what I'm saying here is that I'm taking an ontological holism here to say that this practice was evidence of, my assertion is that the crisis of drought aroused in farmers a pre-reflexive disposition to articulate their protest of government response to the drought through the ideology of kingship, which encompasses an historical practice of refraining from corvée labour. What made this inactions particularly potent and exacerbated a sense of crisis was Sirisena's amplification of the ideology of kingship. So that was the context. So in this sense, At the pre-reflexive symbolic level, we can understand why perhaps the protests were uncoordinated and piecemeal. They were operating at a symbolic level, arousing action in people without a need for centralized direction. So just quickly, sorry, to conclude, what my point here is that ecological crisis is going to intensify in Sri Lanka, and there's scientific and policy approaches that seek to intervene at local levels. And this often is formulated through scientific rationality and assumes people are rational beings, which they are. But my point is that ecological crisis always unfolds within particular cultures. And I've outlined a cultural approach here that's specific and a cultural idiom, and that it's important to take these into consideration when we consider responses to ecological crisis. Okay, I better wrap it up there. Thank you.
Thanks so much, Samson.
Thanks.
That's a fascinating discussion of how cultural patterns continue to influence how people will act even far after those state formations are no longer there. Our next panelist is now going to be Sunil Taminaina, who is from JNU, and his paper is going to be entitled Carbon Trading in the Global South, India and a Climate Justice Assessment. Welcome, Sunil.
Hello, everyone. Good morning. Wherever you are.
Sunil, can you
I hope I'm audible.
Yeah. If you can hold it closer to your mouth.
Yeah, sure.
Thank you.
I'll just share my screen. Yeah.
All good.
Yeah. The title of my paper is Carbon Trading and the Global South, India and a Climate Justice Assessment. I try to unpack certain conceptualizations of climate justice that the state, taking the example of that the states in Global South, taking the example of India, and try to contrast these notions with the notions of climate justice from the ground up, emerging from the broader climate justice movement within India as well as the broader Global South. Just to contextualize my presentation, I'll give a brief background. I'll also try to give a rather longish history of the carbon trading regime that it has developed within the UNFCCC, United Nations Framework Convention on Climate Change. But before that, I'll just give a brief introduction to carbon trading, the various kinds of mechanisms that broadly exist in today's world. So the underlying logic of introduction of carbon trading mechanisms within global responses to climate change is that it's a form of mitigating climate change on the cheap. That's the argument of the proponents of carbon trading mechanisms. But a crucial question is on the cheap for who? Is it for the private corporations or for the vested interest driving states concerns, or for the people who are most vulnerable to the risks of climate change? So what exactly is happening through carbon trading, the initiation of carbon trading, is in a reductionist manner, it could be said that it's a creation of a commodity called carbon out of a varied range of greenhouse gases, which have different sources, which have different utility for humans. For instance, large swaths of methane emissions from agriculture and marshland from a lot of countries in the Global South is sought to be treated on par with luxury emissions, the so-called luxury emissions of the global north. So, but carbon trading introduced this quantification, so that quantification and a false equivalence, so that a single commodity is emerged which can be traded. So there are several mechanisms through which this trade is carried out. Some of them are one of them is called cap and trade, which essentially puts a cap on the amount of greenhouse gases a company, a state can emit, and any excess achievement could be traded with other countries who are exceeding their emission targets. Offsetting is primarily project-based mechanism where either the state or the private entity can invest in the project, which supposedly yields emission reductions, and use those emission reductions to offset your own excess in carbon emissions. And there are these voluntary and compliance carbon markets. Broadly, I'll be quick here. Voluntary carbon markets are those which have little regulation, doesn't come under UNFCCC, doesn't come under any state directly regulated mechanism. Whereas compliance is which has some regulation attached to it. The underlying logic, as per neoclassical economics, for promoting carbon markets is that it maximizes efficiency and takes care of externalities. But this argument evidently ignores a lot of power equations in real world, which actually determine the outcome of any carbon market mechanism. I'll list out some of the intrinsic problems of carbon markets. I use the word intrinsic because these are innate to the design of markets itself, design of carbon markets themselves, not a particular implementation problem. Certain key problems I listed here are it doesn't avoid emission reduction it avoids emission reductions at source. The baseline scenarios based on which any emission reduction would be calculated is hard to determine accurately. The additionality criteria, whether any investment that goes into these projects is that investment really the source of any particular emission reduction, or those emission reduction would have happened even otherwise. Permanence of claimed emission reductions, the projects, how permanent are the reductions that are being claimed, and more fundamentally, carbon markets also tend to postpone the very fundamental structural transformation that is required to the economy in which we are living far into the future. I give a brief background of carbon markets within the UNFCCC. The Kyoto Protocol had three carbon market mechanisms: joint implementation, clean development mechanism, and international emission trading. Out of which CDM, the clean development mechanism, is the one which is a project-based one, which under Kyoto Protocol, only the developed countries had emission reduction targets, whereas the developing countries didn't. And CDMs are project investments made by the by the entities within developed countries in developing countries. So there has been since the negotiation of Kyoto Protocol, there has been an extension of even the territorial extension as well as the sectoral extension of carbon markets. Firstly, the land use change and forestry sector has been brought in early 2000s. Then the reducing emissions from deforestation, forest degradation, the forestry related projects are also brought in sometime around 2006, 2007. Then ocean sequestration was also being talked about to be brought into the ambit of carbon markets. Paris Agreement had two market mechanisms, and so what has been the position of global South actors, states on the global South, in the design, in the negotiations of these carbon markets over the period of 25 years now, since the Kyoto Protocol has been adopted in 1998. During the negotiation of Kyoto Protocol, there has been a skepticism towards the intentions of developed countries in pushing these market mechanisms without any prior pilot study or any prior evaluation of how these would work in real life. But soon, several states within the Global South, which are kind of key drivers of the negotiations from a Global South perspective, have realized the monetary benefits that they could accrue because of this CDM, and soon they rather enthusiastically supported expanding CDM and bringing a lot more sectors within the ambit of CDM in particular. What this does actually is what this actually did from a Global South perspective is that it has led the developed countries off the hook and allowed them to contribute to even very rapid rise in greenhouse gas emissions, whereas climate justice, which countries in the Global South have been demanding to be made central to the UNFCCC process. Climate justice demands a rapid and early greenhouse gas reductions, which wouldn't happen if in the case that these major countries within Global South have welcomed CDM as a means of climate mitigation. Now I'll come to India in particular. India has been a flag bearer of climate justice at international negotiations, but this conceptualization that India had put forward for a long time within the UNFCCC fora is largely restricted to the international domain, where the historical responsibility of the developed countries is pointed out, and rightly so, and has been demanded the countries within the global north to do their fair share of climate change mitigation and adaptation. But this conceptualization has been lacking within the domestic arena since the neoliberal reforms of early 90s in the country. Priorities of private capital, even if they are exacerbating the climate crisis, have been favored over strategies aimed at reducing climate vulnerability. India is one of the most vulnerable countries to climate change. We are in the midst of a severe heat wave that's striking across most of the country as I speak. But history of India's position indicates clearly that these carbon trading mechanisms, which have failed to reduce the concentration of greenhouse gas emissions, in turn have let the developed countries off the hook, have been welcomed by the Indian state. Whereas it was also consistently pushing for its share of the market pie, carbon market pie, to increase within the UNFCCC fora, as indicated by this slide. India has been a strong proponent of this scheme called the RED Plus, which essentially says that, to give a brief context to this, RED has been brought in a market-based RED, reducing emissions through deforestation and forest degradation, has been brought in for the state purpose that solving the problem of deforestation could help in tackling climate crisis. But this has been done through a market-based mechanism rather than a fund-based mechanism, which countries like Brazil and Indonesia had been arguing in the first place. But India had a problem here in this scheme because the official figures of deforestation haven't been much within India. So the money that India could get through RED, just the RED scheme, wouldn't be significant. So India lobbied for a market-based scheme, which is called RED Plus, which incentivizes which could allow money to come in for just for the purpose of the maintaining the forests that are existing out there, which may be on paper at least perfectly fine. The problem with this scheme is also that the more you try to control the level of forest and you go into each tree, you account for each tree, you tend to centralize the forest governance and remove the population depend on forest, which is about 100 million, over 100 million within the country, and deprive them of their rights on uses of forests. And but India still went ahead and is still a strong proponent of this particular scheme. India also argued for a transition of Kyoto era credits, which the CDM credits, which had lapsed because of the non-implementation of the second round of Kyoto implementation period, to Paris regime, which contributed to weakening of the already dubious market instruments that Paris Agreement has brought in. The huge number of carbon credits that India had sold for export between 2010 and 2022 amounts to over 275 million, suggests how much the state had been invested on these mechanisms. I'll also just briefly give a brief overview of the recent measures within the domestic realm related to carbon trading. There have been significant moves on carbon trading within India only in the last 1.5 years. For instance, a legislation has been passed through Parliament to set up a national carbon market. A major state of Gujarat, which is an industrial state and a rather wealthy state, has attempted a pilot state-level carbon market. The voluntary carbon market is expected to be implemented sometime later this year, whereas the compliance market within the country is said to be operationalized by 2025. There are several private initiatives that are already underway to provide market platform for a variety of sectors like agroecology and forestry and stuff like that. And there have been restrictions on selling carbon credits that have been brought in last year ostensibly for the purpose of making the domestic carbon market exclusively limited to India's achievement in the national determined contributions under the Paris Agreement, which is kind of problematic.
To interrupt, but can you wind up because
yeah, I'm just on the last slide.
Thank you.
This is the climate justice movement view on carbon trading, which has provided a long-standing opposition to resorting to carbon trading in any form. There have been mobilizations as early as 2002 at COP8 in Delhi. It considers all these red and red plus schemes as schemes that enhance resource grab and centralization of forest governance. So to sum up, these are some of the key fora and initiatives that the climate justice movement within India has seen. But to sum up, this particular quote from the Durban Declaration on Carbon Trading from 2008, in which a significant representation from India was there, history has seen attempts to commodify land, food, labor, forest, water, genes, and ideas. Carbon trading follows in the footsteps of this history and turns the Earth's carbon cycling capacity into property to be bought or sold in the global market. Through this process of creating a new commodity, carbon, the Earth's ability and capacity to support a climate conducive to life and human societies is now passing into the same corporate hands that are destroying the climate. I think I'll end it there. Thank you.
Thank you, Sunil, for that overview of how this is happening in India. That was very informative. I am happy to say that our final presenter of this session is with us. Welcome Arpita Kodiveri from NYU Law. Her presentation is entitled Litigating and Negotiating Climate Compensation, a View from South Asia.
Wonderful, thank you so much. I'm just going to share my screen if I can find it. There we go. Is it visible?
It's coming. There we go.
There we go. All right. Excellent. I think what I'm going to do is actually paint a picture that's still in progress. So it's still developing. So a lot of the work that I'm presenting, in some sense, none of the analysis is settled. None of the legal questions or dilemmas are solved. So this is very much sort of a work in progress kind of piece. And that happens to be both in terms of the situation we find ourselves in terms of international climate negotiations, but also in terms of the kind of wave of climate litigation that we're seeing globally. So it's kind of a product of both legal mobilizations and timely legal developments. So it's a fascinating intersection that's emerging as we speak. One thing I want to note as I take you through this presentation is I'll be sort of speaking both with my lawyer hat on, because I'm a legal practitioner, but also with my scholarly hat on. So I'll use them interchangeably, and I hope that kind of gives you a sampling of the kind of momentum that we're seeing legally, but also some scholarly reflection that's kind of needed. Before I delve into the question of climate compensation, which invariably as a lawyer, when we think of climate compensation, what we're thinking of is a legal remedy for compensating climate harms that are experienced. But the law has conceptualized that or understood that as the term loss and damage. And many of you have probably encountered this term more recently, because in the recent climate conference that was held in Egypt, a loss and damage fund was negotiated. I don't want to spend too much time on this, but just to say that there is an interesting separation being created by the law's imagination of climate harm in the form of loss and damage, which it hasn't legally defined, by the way, neither in international climate law nor in any domestic climate law, particularly in South Asia. And sort of the demand in terms of legal remedies by South Asian countries in terms of compensation and liability. So much so, the Paris Agreement in Article 8, where it talks about loss and damage, it clearly mentions that this will not attract legal language on accounts on sort of the basis of compensation and liability. So that's already sort of one set of legal dilemmas that are at play and are being kind of worked out as we speak. The second is figuring out what kind of climate justice framework should we be applying to the issue of loss and damage. Before I go into the nexus between climate justice and the loss and damage question, I just want to quickly pause and tell you, so far, what is sort of the law's conception of loss and damage been? The law's conception has been that loss is something that's irreversible. So we're talking about irreversible climate harm, right? It could be, say, loss of land because of sea level rise. It's irreversible, cannot be recreated. Damages is something that's repairable and can be compensated for. So that's like one way in which loss and damage is being defined legally, but informally. It hasn't really gone into text yet. Another layer to that is we further divided that up into economic losses and non-economic losses. And you're wondering, why am I giving you all this jargon? The reason being because it goes into how is it in the South Asian context, are climate victims on the ground really going to use something like the loss and damage fund? And that's sort of the meatier part, which we'll come to. The reason I speak about economic losses and non-economic losses is basically economic losses are those where the legal remedy of climate compensation will apply because we can quantify loss and damage. Non-economic losses is more to do with, say, intangible cultural heritage. And in those instances, the legal remedy is still kind of confusing. And so adding to this additional layer of complexity is figuring out which climate justice framework to apply, right? So international lawyers are toying with the expectations that civil society and the climate justice movement is placing on them in terms of climate reparations. And then you see this second image, which was taken in the recent subsidiary body meetings at Bonn, where you had loss and damage finance now. So the reason these two frameworks are being pushed and debated is because reparations demands that we, in terms of like the timeline, we go beyond before 1850, which is prior to the, beginning with the Industrial Revolution and prior to that in terms of colonial harms. And that is a timeline which legally doesn't work very well, because how will one provide evidence to claim both compensation and legal remedy with that kind of framework in mind? The idea of climate finance and loss and damage is a more digestible form for the law to attack this problem. And so that's why we're seeing again some tensions emerge with these frameworks. I realize I'm just like building into the main portion of this, but I think I'm going to skip this slide, but just to tell you that international negotiations have been very slow when it comes to even acknowledging the problem of loss and damage, which is now the third pillar of climate law and policy. So if you see this timeline, you'll see that in 1991, Vanuatu actually brought in this term, but it was only in 2015 that it was even incorporated into the Paris Agreement. So given that slow pace of negotiations, communities on the ground and frontline communities, particularly climate victims, they're realizing that in terms of legal action, negotiations are not going to yield or solve their problems. So with the increasing wave of climate litigation that we've witnessed, especially rights-based climate litigation, say beginning 2012, 2015 onwards with the Urgenda case, you start to see people go to the courts. And this is an interesting case and a fascinating example of climate victims going to the courts to claim climate compensation. So Luya is a Peruvian farmer. He decided to take RWE, which is a public utility company in Germany, to court. And the basis on which he is taking RWE to court is that 0.45% of RWE's contribution to the global carbon stock renders it liable for the glacial melting, which is eventually flooding his farmland. So the chain of causality is fairly convoluted, but just to give you an example, that climate litigation is emerging as a very fascinating space for climate victims to be able to articulate their grievances around loss and damage. And now I'm going to sort of turn the perspective a little bit towards South Asia. And I think the previous speaker spoke to or alluded to how vulnerable South Asia is in terms of climate harm, right? I can't reveal too much, but there are cases being developed now where countries and communities are going to take on what we call fossil fuel majors. Fossil fuel majors are essentially companies whose contribution to the global carbon stock is so large that a climate scientist, Rick Heady, has come out with a list of carbon majors. And so we're going to see a lot of cases where communities are going to go directly to the courts and not necessarily go through negotiations. Because despite the creation of the loss and damage fund, the important question is how much of it will actually go to climate victims on the ground. And so in a lot of my conversations with climate negotiators and civil society actors from across South Asia, namely India, Bangladesh, and Sri Lanka, what you're starting to see is communities coming together to look at strategic litigation as a viable alternative. And as they're doing that, they're also sort of situating it in sort of relational legal strategy, in the sense that they're not discarding negotiations, but they're saying certain things that can be achieved in negotiations cannot necessarily be achieved through litigation. And one more sort of like, I think I can pretty much go to the last slide to tell you a bit in terms of where the future is going to be around both climate compensation and loss and damage, both in terms of as a lawyer working with communities on the ground, but also as a scholar. So I think negotiations fail to hold corporations accountable. You might have heard or read about how Coca-Cola, for instance, was heavily involved in the previous climate conference, or the influence that fossil fuel companies have, both in terms of outcomes and presence in these conferences. So, and it's legally speaking, it is a realm for holding states accountable. So if you already have that kind of gap, then you need litigation to really step in and try and get some funding from corporations to address climate harms on the ground. And I think in South Asia in particular, the challenge that we're going to see is a lot of the fossil fuel majors are state-owned companies. So would it mean that climate victims will have to go after state-owned companies, or will they be going after multinational fossil fuel majors like Luya did? So those are some debates that are still underway. The other thing that I think the reason we're going to see a rise in climate litigation over the next, I would say even the next 2-3 years, is because it provides access to justice to the victim directly. So in some sense, what we're going to start to see is, because climate victims, whether they're indigenous communities or coastal communities or any of the frontline communities bearing the brunt of climate change, it's very hard for them to be represented adequately in negotiations. Litigation at least provides a little bit more leeway and more room for that kind of articulation of grievances in terms of climate harm. I just want to conclude by saying that there is a case in which I'm currently involved in and working on, where we are looking at climate litigation with the objective to claim climate compensation from a fossil fuel major. And just to say that this template of a case is really difficult. It's really, really hard. And a lot of the questions are difficult to prove in court, even if we rely on evidence like testimonies from climate victims. The biggest challenge here is access to good attribution science or climate science to be able to prove that a particular company has then caused sea level rise in a particular coastal village in South Asia, which in turn means that the community can then claim compensation. So this is going to be the new legal terrain on which a lot of the future international climate law and environmental law battles will be fought. I'm going to stop with that. I know it was a little bit like I ran through a lot and probably legally kind of heavy, but I just wanted to pose this because I think it's an interesting area of work, and a lot's going to happen in the near future.
Thank you so much, Arpita, and thank you everybody for your presentations. I learned so much from this session as we had discussions of new legal frameworks, new international legal frameworks that are emerging, and how precedents might work within them, at the same time as this new the way that the commodification of carbon and carbon trading is going, both seen with reference to South Asia, and then from Samson, how different patterns from historical precedents continue to emerge as people try and get direct access to justice. So we do have a few minutes for questions, and I have to apologize that I actually have to go into a different Zoom at noon, so for 10 minutes from now. So I'm going to turn the question moderation over to Saloni, just so it can be a seamless experience for everyone. So thank you, Saloni. We do have one question waiting in the Q&A, and then I would love to hear if anyone else has questions, and if you among the panelists have questions for each other, and I'll stay on till the last minute. Thank you all very, very much.
Oh, hi everybody. So we have a question from Marufa. So that question is, how much carbon does India have in 2022? Does UNFCCC buy all these carbon directly from India or through CDM projects? I think this is for Sunil.
Hi, yeah, I'm assuming you are asking, Maripa, how much India emits annually. How much carbon does India have? I think that's hasn't been estimated yet. I mean, that implies cumulatively counting the amount of carbon that India holds in all of its forests, in uh, all of its tree cover and a lot of other things. So, but to the question, how much does India emit annually? It's about 3 billion tons of carbon dioxide equivalent, which is roughly, I think, around 8% of the global carbon emissions annually, which is around 40 billion tons of carbon dioxide equivalent. To the following question, does UNFCCC buy all these carbon dioxide from India through CDM projects? Well, this is a complex terrain right now because even the second implementation period of Kyoto Protocol, under which CDM is present, has elapsed at the end of 2019, whereas the Paris architecture hasn't really kicked in so far. And the rules have been finalized at Glasgow, but the final nuts and bolts are still being negotiated. But so some of the credits from the previous era have been transitioned to the under the Paris architecture. Not all, but a significant amount of them have been transitioned. So that will be under the Paris architecture, which could be traded as it gets into operation. Yeah.
Thank you so much for your answer. And for other attendees, you can put in your questions in chat for Q&A, but at the same time, do panelists have questions for each other where you want to have that conversation?
I have a question for Apita. I was just thinking, you were saying that it's increasingly the case that some communities that are affected by aspects of climate action are circumventing negotiations and going straight to court. And you were saying that oftentimes those negotiations tend to favor those bigger players like corporations and things like that. Do you have any sense of if these decisions by communities are coming from that grassroots level, they're cognizant of these negotiation process not supporting them? Or is this something that's happening externally, people coming in and saying this isn't the best option for you, we should take it in this direction? And so I'm sort of asking, are people becoming increasingly cognizant of these power structures are not sort of there to necessarily support you as they are? We have to try and find alternative avenues.
Thank you so much for that question. I think a lot of this legal theorization is on account of climate lawyers emerging as this new breed and a new epistemic community, and they're heavily networked. Imagine someone like me doing a postdoc here at the Climate Litigation Accelerator is thinking about cases in Latin America. And so this idea of cross-fertilization and cross-jurisdictional learning is happening in a very, very fast pace. And I've been an environmental lawyer in India before, and I haven't experienced this level of kind of sophisticated thinking. And I'm so glad to kind of be part of this community. It does come with its own challenges though, because then what you have is a specialized community of climate lawyers determining legal strategy. So how much then are communities on the ground aware of this larger legal landscape? I think with indigenous communities, it's very different. They're really, really well tuned and aware of the scales at which the law is operating. So even if you look at a case that's been filed in Indonesia against a cement company, the community there is an indigenous community, and they are aware of how these different links are playing out and why they're doing what they're doing. But in some of the cases that we are thinking of bringing, what we're struggling with is not trying to sort of juxtapose negotiations and litigation, but rather the news that's traveled now is that there's a new fund. So there's a new fund that's been created, which eventually is going to trickle down to communities on the ground. So the question now is, will I get access to that fund? Because we're talking about communities bearing the costs of extreme weather events. There's no insurance. A recent study by ICAD in Bangladesh proved that communities who are earning $200 a year are spending 30% of their income on just bearing all the climate harm. So in some sense, there's also anticipation for some kind of support. So there is a lot of frustration on the ground. And the frustration is not something they can articulate against the state, because the state is sort of looking towards negotiations to resolve the problem. So that's kind of the link being naturally drawn, apart from climate lawyers stepping into trying to save the day. Yeah, I don't want to give us any kind of crown, so to speak.
Thank you so much, Arpita, for your answer. And just like Anna said, from all three of you, I am learning so much as well. So thank you so much. Does anybody else have questions for each other? Okay. Yes.
Hi, Arpita. Thank you for a fascinating insight that you provided into the current status of legal endeavors towards loss and damage. You particularly focused on loss and damage, but I just wanted to ask if more instead of, I mean, has there been prayer in earlier times, prayer litigation in any significant way on enforcing adaptation, say PILs in the form of PILs, or within the Indian context, of course. Say, for instance, I mean, in the Sundarbans side, putting up sea walls or something of the sort. I mean, just wanted to know if there are any such litigation that existed.
Thank you for that question. I think that also kind of speaks to the evolution of this term climate litigation, right? Like it completely assumes that there wasn't any litigation feeding into good climate outcomes prior to the creation of this term. But in the Indian context, what we've had is very, very robust environmental litigation, which is like a hidden climate jurisprudence. And what's fascinating about that is this question of adaptation. So there are about 3 cases, in fact, I can maybe share it with you over email, but one case that comes to mind immediately is, I think the Bombay Environment Action Group challenged the construction of an airport in Bombay, where the mangrove forests were going to be lost. So they said that the mangrove forests have to be conserved as a way to adapt to climate change, given that they protect us from cyclones and other kinds of effects. And so you saw a lot of these like hybrid cases, which were PILs in terms of environmental litigation or biodiversity litigation, but having this kind of underbelly of climate. I do think now we're going to see more pure / specialized climate cases in the Indian context, but the politics around it are such that you will see more adaptation and loss and damage cases and not too much on mitigation, especially at the intersection of coal and mitigation. That I think will still be fought on more traditional legal grounds like land rights and forest rights and that kind of thing. But yeah, we do need to have more sort of concerted research, I think, on India's story around climate litigation without really using that term. Yeah, I actually had a question. I don't know if there's time for that.
We do have time.
Okay, I guess I had a question for both Samson and Sunil in terms of South Asia. Where do you feel like a lot of the, like, I know that you guys are sort of specialized in your areas of research, but do you broadly feel like there is a community of researchers on climate issues in South Asia? If so, is there a community that you're a part of, you draw from? Like, I'm just trying to understand how the learning happens across. I know this conference is one attempt to do that, but yeah.
I'll go first. Yeah, I think it's a fairly it's a I mean it's a tough scenario here. There are emerging climate change centers
Can
within
you hold your
university
mic
spaces.
towards your mouth?
So there are emerging centers related to climate change. There's one in Mumbai, and APU has one, APU Bangalore. But otherwise, researchers working specifically on South Asia, I'm not aware of a such. There are, of course, activist networks and mass organizations for the platforms and networks of them. Researchers that are not that.
Yeah, I think, yeah, I haven't found a lot in my own studies, and I think that from what I've seen, there's kind of research emerging, but I suppose from where I'm working from, it seems sort of very still at the kind of technical policy, perhaps more scientific realm. And so I think this conference is salient because I think the social sciences are kind of starting to catch up a little bit, and certainly, so it's an emergent thing. And I'm certainly seeing that at certain points, some of those scientific approaches are sort of seeing some sort of deficit in their own approach and saying, okay, we can come up with all these models and formula and whatnot, but there's this other side that we aren't quite capturing. I'm seeing anthropologists being asked to come to peak bodies and saying, well, we realize this is happening, but you know, what do? We can't just move people over here because they have religious beliefs or they have this and that. But I think they still aren't sure of who we are or what we do. We realize we need to get these social sciences, but we don't quite understand. So I feel like from our perspective, at some level, we're trying to kind of speak to that and understand the scientific approach to kind of like get our foot in. So I feel like it's still emerging, and just, yeah, from my perspective, I haven't encountered a lot of bodies that are perhaps more oriented to the social sciences trying to speak to this issue. And that's something I'd really like to try and almost bridge that gap into the things that I'm doing for sure.
Thank you. And also, just like Arpita mentioned, this platform and the symposium is one of those places, and we would obviously love for you to attend all the panels and keynote presentations and talks. We have one with Dr. Qazi Ashraf today evening, Hawaii time. I know it'll be a little late for a lot of different time zones, but that talk will be live streamed on our YouTube channel and will be posted there as well for you to hear him in the future. At the same time, please do attend all our other panels. We do have a little time for one more question if you all have if there's some question that's coming up in your mind. If not, we can also stop here. Thank you so much once again for all this information. I mean, this is all groundbreaking. And again, I learned, and I think Anna, just like Anna said, we learned so much from all three of you. Thank you so much for participating in Center for South Asian Studies Symposium. And we look forward to see you at other panels and hope you enjoy the other panelists' presentations too. Thank you.
Thank you so much.
Thanks very much. Thank you, everybody.